Okay, hi everyone. Good afternoon and good morning from wherever you are. My name is Anne Nathakan Chumputong. I am a lawyer and also legal trainer from Babsico in Thailand. Welcome to the session. In this session, we will talk about the annual Asia Pro Bono mock pre-trial workshop and event, which is a regional signature event that engages students and legal trainers from Asia region. This impactful event has been developed and strengthened through collaborative pro bono support from throughout the Asia region globally. In this session, we will demonstrate the goals and impact of the regional initiative. First of all, I would like our presenters to introduce themselves. Maybe we start with Ji Yang from YNKs, please.
Thanks, Anne. Hi, my name is Ji Yang. I'm from YNK's Singapore team. The capital markets team, and I'm happy to be here to present today.
May I, Anne?
Yes, please, Roshani.
Hello, good afternoon, everyone. It's me, Rosni Paudel from Kathmandu. I'm a lawyer and I'm an assistant professor in the Nepal Law Campus, Tribhuvan University. And I have been engaging with these regional pre-mock trial and other pro bono activities of these, led by the Babsicle. It was pleasure to be here to engage with this pre-mock pre-trial, which is very interesting and exciting event. Thank you so much.
Hi, and if I could just jump in. So my name is Philip Tan. I'm an associate at YNKs in Singapore in the international arbitration team, and I have participated in the pre-trial workshops last year in a virtual setting, both in the national workshops as well as the regional workshops, and then finally kind of judging the pre-trial hearing event as well. So it was a great experience, and I'm looking forward to sharing my experiences with everyone on this seminar. Thanks.
Thank you. And I think we have other two students, not sure if they have already joined. Okay, it's not, I think they will join the session later to share a bit of the reflection about the training and event. Okay, Nana, can we please have a slide PowerPoint up please, again? Okay, so before we get into exact what a pre-trial hearing is and how it differs from a trial, I'm going to start by telling you about a real life case. And it's not a case that I did, it's a case that Bruce actually worked on when he was a young attorney in the United States. So he worked as a public defender in the United States in a state of Florida. So Bruce was assigned as a public defender to represent someone who has accused of a crime. Here is the factual scenario. Bruce's client was at home sitting in his living room, just enjoying this afternoon, and the police came to his client's door, and the police knocked on the door, and client opened the door and saw that there were police on his doorstep. The police said, "Can we search your home?" they did not have a search warrant, so they did not have permission from the court to search the home. But they asked the client, can we search your home? And the client said, no, you may not search my home. But the police went into the home anyway. The person said no. And they searched the home, and what they found were drugs. They found cocaine. Then Bruce's client was then arrested. And there was going to be a trial to determine whether the client was guilty or not guilty of possession of drugs. Okay, so from this scenario, we are going to do a poll. So again, the police came into the door and they asked permission to enter the home, and client said no. Police went into the home anyway, and they did find drugs, and the person was arrested. From this scenario, should the prosecution be able to use this evidence against the defendant? Maybe take while we're waiting for the poll, take a couple of minutes, think about this. Okay, the poll is up. Now we have 11 people say yes and 12 say no. Okay, let's end the poll and publish the result. Everyone can see the result, right? Okay. We have 48% say yes and 52% say no. The evidence or the drug should not be allowed to use as evidence. Let's hear from the person who say yes. Would you like to share why you think the evidence should be allowed to use in the trial as evidence? Anyone who answer yes would like to share? You can type your answer in. Okay.
ข้าพเจ้าขออนุญาตเนาะแลกเปลี่ยนกับผู้บรรยายต่อกับปัญหาดังกล่าวครับแล้วในการที่จะถือว่าเป็นหลักฐานหรือบ่เนาะก็มาเบิ่งเรื่องหลักการข้อกำหนดของกฎหมายตื่นเนี่ยว่าโดยหลักการแล้วเนาะในการที่จะกวดค้นเคหสถานหรือว่าเรื่องของบุคคลใดบุคคลหนึ่งมันต้องมีคำสั่งจากหัวหน้าองค์การอัยการหรือว่าศาลเนาะแต่ในนั้นเนาะสำหรับกฎหมายของสปปลาวมันก็มีข้อยกเว้นอยู่เนาะคือในกรณีซึ่งหรือว่ากรณีหีบด่วนนี้เนาะก็สามารถดำเนินการได้คือกันเนาะเพ ราะในกรณีดังกล่าวนั้นเนาะทางอัยการหรือว่าเจ้าหน้าที่ตำรวจอาจจะมีข้อมูลหลักฐานชัดเจนแล้วว่าอยู่ในเรื่องเนาะของผู้เกี่ยวนั้นแมนมีหลักฐานหรือว่ามียาเสพติดหรือมีสิ่งที่ผิดกฎหมายอยู่ในนั้นเนาะพอข้อมูลชัดเจนแล้วเนาะในกรณีนี้เราสามารถดำเนินการได้เนาะถ้าหากว่าบ่ดำเนินการตรงนั้นเนาะไปขอคำสั่งก่อนเนาะจากศาลจากอัยการมันก็อาจจะเฮ็ดให้ผู้กระทำผิดหันไว้ตัวท่านผู้เนาะผู้ก่อนเนาะหรือนำเอาหลักฐานดังกล่าวที่เป็นยาเสพติดนี่ไปซุกเสียงไว้หรืออาจจะเอาไปทำลายทิ้งเนาะในกรณีนี้มันจะเฮ็ดให้บ่สามารถเนาะที่จะสอบคนพวกเป็นหลักฐานในกรณีที่ว่าไปต้องไปขอคำสั่งก่อนเนาะจึงมาดำเนินการค้นคว้าหันพร้อมต้องเบิ่งเนาะอิงตามกรณีคือกันเนาะถ้าว่าในกรณีธรรมดากรณีทั่วไปหันเนาะในกรณีนี้มันต้องแน่นอนว่าต้องมีเอกสารเนาะที่เป็นทางการนั้นก่อนเนาะยกเว้นกรณีซึ่งหน้าที่ด่วนนี้เพื่อหาประกันเนาะให้การดำเนินคดีนั้นมันสามารถดำเนินไปได้เนาะแล้วก็หาประกันให้ได้ข้อมูลหลักฐานตามที่เราต้องการเพื่อที่จะลงโทษผู้กระทำผิดเนาะเพื่อจะดำเนินคดีกับผู้กระทำผิดขออนุญาตได้เปลี่ยนน้ำสำเนียงเนาะขอบใจ
Thank you very much for your participation. Now let's hear from anyone who say no. Would you like to share your argument why you say no? The evidence should not be allowed to use in the court. Please feel free to share. It's not right or wrong. It's fine. You can share your opinion. Okay, that's all right. Let's move on. Now I would like you to put your hands up and do like this. Okay, everyone. Okay. I would like you to type in the chat whether in your country, whether the evidence that illegally obtained, whether it can be used against the defendant. Do you have the law or procedure about this in your country? Just yes or no, type in the chat. Okay, I'll count down 5, 4, 3, 2, 1. Send in the chat. If you are not sure if you have a law or procedure in your country, you can say not sure, it's okay. Okay, we see yes from Thailand, yes from Laos, and Myanmar. So depends on the jurisdiction. In this scenario, the drug found in the house could be considered as unlawfully obtained evidence. When this kind of scenario occurs, many countries have pre-trial and exclusionary hearings where the motion to exclude is filed and a court decide whether or not illegally obtained evidence can be used in at trial. I'm going to talk a bit about what is motion to exclude and why we have a pre-trial hearing. A pre-trial motion is simply an application to the court to hear an argument about an issue before the hearing itself commences. Especially, advocates can file pre-trial motion in order to exclude evidence from being used during the trial. In criminal trials, pre-trial motions can be filed by prosecutors and defense advocates. In civil trials, this motion can be filed by the plaintiff advocates and defense advocates. There can be many legal reasons why some types of evidence should not be allowed to be used during a trial. The ability to file a pre-trial motion and have a court decide before the actual trial whether some evidence can be used at trial is a core part of ensuring a fair trial. A pre-trial hearing is not a trial itself. It's a hearing where a court is asked to make a decision on some legal or factual issue before a case goes to trial. Many times at a pre-trial hearing, the court will hear arguments from prosecutors and defense advocates as to why the evidence should or should not be allowed to be used at trial. Often during a pre-trial hearing, advocates and prosecutors call witnesses and provide the court with other types of evidence in order to try to convince the court that certain evidence should or should not be allowed to use at trial. Prior to a trial hearing being held, advocates and prosecutors file a pre-trial motion asking the court to either allow or exclude certain types of evidence. If an advocate or prosecutor wants the court to exclude certain types of evidence, they usually file what is called a motion to exclude evidence. And during the pre-trial hearing, both prosecution and defense advocates will try to convince the court through both witnesses and documents that evidence should or should not be excluded during the trial. The prosecution will try to convince the court that the evidence should be allowed to be used at trial, and the defense advocate will try to convince the court that the evidence should not be allowed to be used. So in 2004, basically we held the annual mock trial pre-trial hearing event for students across the Asia region with the purpose to support and strengthen the value of rule of law, fair trial, and access to justice. The program further aimed to advance and increase the pro bono movement across Asia. The event is not focused on law of particular country. It is done with the aim of developing legal, analytical, and advocate skills, increasing familiarity with the court process, and enhancing participants' appreciation and understanding of legal ethics and access to justice. I think some of you have been involved and observed in the mock trial workshop and event. Can you show the thumbs up use the thumbs up button if you have been involved or observed in the workshop and event. Thank you. So we began doing with the traditional mock trials, but we realized that one of the best ways to demonstrate proper rule of proper rule of law and fair trial principles is to do the exclusionary hearings, which is focused on the police powers and how they are needed, and but also need to be limited and controlled. So we also saw that in the region, many practicing lawyers had no idea how to challenge evidence and try to have it excluded, even though they had rules in their jurisdiction that prohibited the use of improperly obtained evidence. So at the beginning, we held a workshop and event physically in Chiang Mai, Thailand, and in 2020 and 2021 we have been organizing in virtual format due to the COVID-19. And in organizing this event, a lot of work has been putting into the preparation, materials, development, and implementation. We Babsicle has been working closely with law firm partners, including DLA Piper, Herbert Smith Freehills, and New Perimeter, and university partners, including University of Queensland and Queensland University of Technology and Brandenburg Chambers to develop materials and implement this program. And the materials are reviewed by many other trainers and judges. And you can see, yeah, this is the example of the materials that we use in the workshop, training, and the event. And their commitment of these partners involved in the material development, including student handbook, facilitator handbook, case package, which include case scenario and the law and other training materials. And each of these handbook is over 100 pages, so it's very thick. And in addition to the material development, these partners and lawyers also assist as trainers and judges at the workshop and event, and this is supported pro bono. And White and Case is one of the main partners that help implement this program with the training and assist as the judges at the event. So I will give this over to Jiang from White and Case to tell us more about the training.
Thank you, Anne. So, just basically we had a training structure, if you can see here on the slide, that consisted of 3 phases. As we alluded to earlier, there's a national workshop, a regional workshop, and finally a pre-trial hearing event, where participants were selected for the event and will apply the acquired experiences from the previous 2 national and regional workshops in a similar to court setting. And my colleagues also had a chance to be a judge on this event. Next slide, please. No, and if we see the topics that we actually go through during our sessions and the workshops, you get a better understanding of how we sort of go into detail on the pre-trial topics. So we deal with issues such as what is a pre-trial hearing, case planning and case theory, opening statements, evidentiary issues, witness examination techniques, closing arguments, witness prep. All this, how they all tie together for simulated court hearing. Next slide. So at, sorry, at the national workshop, our pre-trial hearing is it's a form of legal training that provides platform for potential legal practitioners from many countries to improve legal skills. So this was more on the national level. And next slide. Next slide, please. We have done this national workshop in a total of 8 countries and across the Southeast Asia and including Bangladesh. So we went to Cambodia, we did this in Cambodia, Indonesia, Laos, Myanmar, Nepal, Thailand, and Vietnam. Next slide. Yeah. And if you see the timeline, we had quite a long run. We started in October, 16, 17 October in Myanmar, and we progressed through to the various countries, every other week. So there was Laos in 23rd and 24th October. 30th, 31st October was in Nepal, Vietnam. 6th, 7th November was Bangladesh and Indonesia. And 13th and 14th November was Cambodia and Thailand. Sorry, back to the previous slide. If I could just get the participants to, maybe have a think of how many students, how many participants, and how many trainers we managed to engage in during our sessions. Maybe have a think of that and maybe put some answers that you might think is the correct answer into the chat box. And then we can take a look and see what's the actual figures that we had. I'll give everyone maybe 30 seconds to think about how many students, how many trainers you believe participated in the trainings, and feel free to write them in the chat box.
I give you a hint. It's over 50.
Especially given that it was virtual, yeah. Maybe 10 more seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Time's
Okay,
up.
yeah, we have some answers. More than 100, definitely, yeah, and 500 plus. I think that's yeah. If we go to the next slide. Maybe not 1,000. So in total, we had 296 students. And if you can see on the slide, it's quite a good mix between males and females, as well as across the countries that we reached out to. 15 in Bangladesh, 49 in Cambodia, 20 in Indonesia, 41 in Laos, 14 in Myanmar, 36 in Nepal, 35 in Thailand, and 51 students in Vietnam. And if you see the ratio, the gender ratio across, it's quite a good mix. If we go to the next slide. And we managed to engage a total of 39 universities from these 8 countries. And I won't go through every one of them, but you can see on the slides which universities we managed to engage during our various workshops at the various countries. And as for trainers, we managed to engage 11 countries, and in total we had 19 trainers from 14 organizations. And once again, we had a good mix between male and female trainers, and this was quite an astounding feat. 19 trainers across 14 organizations. And 11 countries, we managed to engage not just the trainers from the countries that we went to. We even had Australian trainers, Singapore trainers, US trainers, and even Japan trainers and Hong Kong trainers. Next slide. And on the regional workshop level, top students from each of these national workshops were selected to participate in a 2-day virtual event. And selection was based on knowledge about the case, as well as a diversity across gender and race. And in this workshop, we focused on sharpening the legal skills that we taught during the national workshop, as well as developing critical thinking on legal ethics issues. And yeah, sorry, it's okay. Next slide, please. And this time around, it was a more selective session. So we had 54 students across the various countries, and only a handful was selected from each country. Next slide. Once again, the trainers were also more selective. We had 5 trainers from 3 organizations. And the main countries, or rather the only countries that we came from were Laos, Singapore, and Thailand. Next slide. Now, finally, for the regional mock pre-trial event, we simulated a case involving a pre-trial hearing to exclude evidence in an upcoming criminal trial that police obtained during a traffic stop. And we took place in a hypothetical jurisdiction, so we don't focus on any particular laws. And participants, they had a chance to practice legal and analytical and advocacy skills in a simulated courtroom. And we also got to experience, and they also got to experience, courtroom procedures and gaining an appreciation of fair trial and the various concepts such as rule of law and legal ethics. Next slide. We managed to structure the event such that there was the practice round. There were 4 teams. Each team had 5 roles, and then we went to the bonus round, the semi-final, and the final. So each one was a chance for our participants and the hand-picked students to practice their legal skills and go through all the concepts that we had talked about. In each team we had various roles. If you see on the slide now, you have 2 main teams, obviously, the prosecution and defense team. And we broke the roles down quite variedly. So there's 2 prosecutors, 3 witnesses, and 2 alternatives, as well as 2 defense advocates, 3 witnesses, and 2 alternatives. And in this event, we managed to engage 41 students. Once again, was across all the various countries that we had gone to. It's quite a good mix of both the genders as well as ethnicities. For this pre-trial event, we managed to engage more judges to sort of judge the event. We had 16 judges from 12 organizations, and they were from a variety of countries in the Asia Pacific region. Australia, Bangladesh, Iran, Laos, Singapore, Thailand, US, and Vietnam. And the scoring evaluation of the pre-trial hearing was done on various merits. The judges were not ruling on the case or the guilt or innocence of the accused, but instead on the student's performance at the pre-trial hearing, and the cumulative scores of all the members were added together so that judicial opinion had to be agreed to by more than half the members of the court. Next slide. Yeah, and this was an example of the scoring sheet. And here we have the evaluation that we got. We asked the question in a pre-trial hearing. The judge decides whether the accused is guilty of a crime. And post-test, we see the scores go up by quite a bit across all the jurisdictions, all the workshops that we went to. In Myanmar and regionally, we had 100% correct answers post-test. In Laos, we had 106% improvement. And across Nepal, Vietnam, Bangladesh, Cambodia, Indonesia, and Thailand, we saw a very good improvement in the post-test answers. So, we touched upon reflections on the background, the trainings, and how the trainers had to prepare, how the students were engaged throughout the trainings, and how it was clear about the students' growth in the training.
Yeah.
Yeah.
Hi, GM.
Yeah.
Maybe I could just jump in and do we have some students on the line as well right now?
Yes.
Okay, great. Yeah, no, so perhaps maybe I could start by sharing some of my reflections, and then obviously I think it'd be great for the students to share what their reflections are. Obviously the course, the workshop and the event is meant for them. It's a training program for them, allowing them to go through a very practical hands-on experience, going from the national and regional workshops where they kind of learn the various skills to actually presenting and working together as a team in the actual event. By way of reflection for me as kind of trainers through the workshops, as well as a judge, as well as being a judge at the event itself, I saw a tremendous improvement in the kind of skills and the learning of the students through the national workshops all the way up to the event, where I mean, at the start, students ranged from, I would say, a variety of backgrounds in terms of whether they were uni students and kind of which year of university they were at, and also in terms of language and their training. They might not have actually had much experience, if at all, with these sort of pre-trial issues, which could be quite technical legal issues. And I could see how the students really grappled with the issues very well. Obviously, it's a very thick handbook, as well as has been kind of presented previously. It's a very thick course handbook of hundreds of pages, not only for the facts itself, but also the kind of various witness statements. And you kind of have to act really different roles, right? So on one hand, you could be acting for the prosecution, on one hand, the defense, or even a witness as well. So you have to, for example, act as one of the police officers who kind of saw what has been happening, and you have to kind of defend your position on the stand and explain why you did certain things or why you didn't do certain things. So there's so many different angles that the students could play. And for me, it really was great to see how they kind of engage with the material very well, engage with the roles that they had to take on throughout the workshops and the event. And they did so very well as well. And obviously it'd be great to, I think the last week's session, we we're kind of talking about how it'd be great to expand it to many other countries and to get more participants involved. Obviously the last couple of years were done virtually. I think where we could do it physically next time as well, I think that would be even a better enhanced experience. And I think with that, perhaps we could, and if you want to share anything, or perhaps we could turn it to the students to kind of share their thoughts on what went on. Who are the students on the line? Should we ask them?
Yeah, I'm one of them.
Hi, Shruti. Hey.
So starting on, I'm Shruti Sarma, and I'm from Kathmandu, Nepal, and I'm currently a BA LLB third year student at Kathmandu School of Law. So I'll be sharing my experience and reflections about the training and workshop of a mock pre-trial that was held a year back. So, but before getting into my experience, firstly, I'd like to thank the BAPSICLE team for creating and providing such a wonderful platform for law students to learn advocacy skills, build networks with people from different parts of the world, and gain so many other experiences and skills. And also, I'm very grateful to the BAPSICLE team for letting me share my experience about the mock pre-trial as a finalist of last year's event. So talking about my experience as a participant in the mock trial training session, I have to say it was very engaging and enlightening. The mock trial gave me an opportunity to practice what I have been taught at university, particularly the criminal trial advocacy side of things, incorporating legal teachings as well. So as I mentioned, I am from Nepal, and the legal system and trial proceeding in Nepal is quite different from what we practiced in the mock pre-trial. So at first it was pretty new and challenging for me, but experienced trainers, workshop reading materials, handbook, and rigorous practice and interaction between participants right after the training made the session more interactive and fruitful, I believe. And starting from the training and workshop on the opening statement to the closing statement, I could feel that I was more confident than ever, and I developed many skills throughout. So, what was the thing that stood out most for me was that learning was never this fun, and I really enjoyed every training and workshop session. And so basically, there were two rounds. First one was national round, and the second one was a regional round. And after selecting from national round, we advanced to regional rounds. So later on, there were many workshop sessions and training sessions, and later on, there was a main selection round for the main pre-trial event. So for the main round, we were assigned into different teams, and in my team, I was the only Nepali, and all of my other teammates were from different countries. So the first few days were a little tough, as we had differences in our accent and we had hard time communicating and understanding each other. But later on, we got acquainted with each other's accent, behavior, and skill. And each and everyone on my team were very hardworking and dedicated. So we used to discuss and practice every day for a few hours after training. And this was something that I enjoyed the most, and mm, most about the mock trial. So, keeping all these fun and challenges aside, the most important thing that I learned about was criminal trial and its execution, mainly pre-trial hearing, and different types of evidences and their importance in ensuring access to justice, and how all these concepts implied that one should not be subjected to deprivation of any rights in order to ensure fairness in the trial. So the case that we were assigned or given incorporated questions regarding the admissibility of evidences collected through illegal searches and seizures, and confessions made under undue influence from the police officers during interrogation, which hindered the accused right to fair trial and access to justice. So access to justice is a fundamental to establish and maintain for the establishment and maintenance of rule of law, because it enables people to have their voices heard and maintain the rule of and to exercise their legal rights. So access to justice is an indispensable factor in promoting empowerment and securing access to equal human dignity. So so no one shall cause or try to cause hindrance in due process of law. Fabricated evidences and evidences collected through illegal measures should not be admissible in the court, and lawyer of both the parties, that is prosecution and defense, and along with them witnesses, judges, and other judicial officers and members play a huge role in ensuring and departing justice. And this is, I think, the most important takeaway for me from the whole mock pre-trial workshop and the main event. So all in all, when I have to narrow down my experience about the mock pre-trial workshop and event, I would say it was very fun, engaging, and very productive. And I believe that all these skills and knowledge that I gathered when performing or participating in this mock pre-trial event will allow me to handle the pressure of the real courtroom in the future. Yeah, that's it. Thank you. Thank you so much.
Wow. Thank you, Shruti. Thank you for sharing, like Shruti share that after the regional training, the students will evaluate from each country, and number of them were chosen to participate in the regional event, and the student will be mixed up in the team. So in one team can be students from different countries and different university. So this event is not a competition, but it's a learning experience. So they, in addition to the court procedure and the law, they also learn how to work together. Okay, let's hear from another student. Udom Rat, please, over to you.
Yes, am I audible?
Yes, yes, we can hear you.
Thank you. Hi, everyone, and all the participants, distinguished guests and judge, and all the lecturers who share the experience to our participants. My name is Rod Udom. I'm from Cambodia. I just graduated from English Language Bachelor of Law at Royal University of Law and Economics in Cambodia. I was the former participant with Shruti in the defense team, which we rotated a lot of roles in our performance before. Actually, the reflection that I want to share here is that the events run like the real competition and simultaneously virtual pre-trial hearing in a courtroom. The event rounds encompass all skills to be noticed in the course of evidence admission. Though this kind of proceeding may not exist in some countries, including Cambodia, but it gives logical and reasonable impacts to legal practitioners in developing countries to review for necessary reform. Throughout the events, I noticed the animated simultaneous pre-trial hearing procedure and rules of evidence provide rights and obligation for the prosecution and the accused. And these enhance the critical thinking of the participants to figure out minor details in the case from witness examinations. In practice, there would be some innocent people were prosecuted like Ultra Parker. So the pre-trial procedure and rule of evidence from PepsiCo will give a great insight for participants who dream to be a counsel or a judge, to embrace more elements in the event of legal loophole or the purpose of legal reform. Therefore, both PepsiCo and the participants would together nurture justice and rule of law by approaching them in different ways. And this is what I got from the events. Working with my team, we feel like a lawyer working together at home. They were hardworking, negotiable, and all the discussion went through compromise and team spirit. This made our team function in a very good synergy. In the semi-final round and final round, we rotated our members in different roles, demonstrated the maximum expectation of PepsiCo in justice and rule of law. When it comes to the challenge about the event, it were the admissibility of the evidence, and the case was a closed case. Furthermore, the case was governed by a procedural rule and evidence law of an animated state called Sultanate. So to tackle some problem, those could only be addressed in chief examination and cross-examination. After the events, I get to know the essence of rule of law is not to favor one side according to what has been found on the ground, but to look at the relevant circumstances, including police discretion, due process, witness statement, reasonable person's view on situation happen, and other elements as the case may be. The inherent value of these elements shall be guaranteed by the court, conducive to maintaining the equilibrium between the prosecution, police, the accused, and victim. Simply put, the check and balance. Also, justice is a public good to which people are entitled and thus require public engagement. And for this reason, we welcome the fact that Babsicor have some universities in Asia country to access to this course of justice in a virtual way, while creating favorable conditions for students in issue analysis, statutory interpretation in between rule and exception, and how to utilize evidence to address questions in closing statement. Ultimately, we will bear in mind the fundamental principle of fair trial when we turn to consider any case and remain true to the original legislative motive when we interpret the law in order to maintain consistency and continuity of justice. That's all I want to share. Thank you.
Thank you very much. Now we hear from the trainer and also from reflection from the student. And at the end, if we have enough time, we may be able to hear from some of the Lao students who have been involved in the previous event. Now let's hear from Roshani, who has been involved as both trainers and judge, to share more about judging of the event and her experience. Over to you, Roshani.
Thank you, Anne, and thank you, everyone. It is really a pleasure for me to share the experience as a trainer and as a judge of this very exciting event. Actually, you know, when I was there as a judge and when the students from either the prosecutor sides or the defense lawyer side, they called you like your honor, and really it's a simple word, 5-digit word, but it has a huge, I think, impact and the magic that it can create. You know, it gives you a sense of huge responsibility on you to, you know, to do your job based on a neutrality, impartiality, and this kinds of sense that I can really feel when I was there as a judge. This is the one, I mean, interesting, my feeling that I would like to share. And apart from this, actually, I was participated in the event in 2020 and 2021 in virtual model. And even it was in virtual model, it was like a regular mock trial, you know. It doesn't feel that we are doing through virtual, because we all have to follow the rules of the evidence, conduct examinations, present opening and closing arguments. So all the things, what actually happens in the courtroom, in the pre-mock trial, in the virtual, we also followed all the things. So the difference was that, you know, that was all happened in a computer, laptop based, or sometimes, you know, due to the difficulties like in our country, due to, you know, the not a strong internet connections, we did it in a mobile based simulated environment as well, and that was quite interesting to all of us, I think, for all of us. And basically, this event was an educational event. This is an educational event. The main purpose of the event is to impart not only the knowledge, but the skills, basically the advocacy skills, learning skills, to develop a critical thinking skills, and to develop a networking skills, all the skills that as a lawyer that you have to build on. This session, this event is trying to impart all those necessary events, and it was quite interesting part. And as a judge, the one more important thing that I would like to share is that, often we are thinking that only the students, they need to do lots of hard work. Only the students, they all have gone through the all the materials, reading books and all the things. But what I found in this workshop is that as a judge, you will not, get extra privilege, because as a judge, you also have to do all the preparations, including reading of the materials, reading of the things, and you have to build up your own opinion and with the critical, the things. That's why I think as a judge, you will not privileged as judge, because you have to do all the preparations to take part in the session as a judge and to provide a score or award the scores to the students. So all these rigorous exercise realized you that you are also a student. So this is really a good thing for me that I experienced, that as even performing as a judge, you have to be a student to learn the things. This is very important thing that I would like to share. And what also I found about the students is that they are representing from all over the different part of the country, and whatever may be the role they were performing, like a prosecutor, defense lawyer, witnesses. They almost all of them were very prepared. They all have the enthusiasm to learn something, to develop networks. So they are very, very confident as well. And throughout from the national workshop to regional, what I found is that they all have grown up, and the tremendous growth that I found into them, throughout the event. So this is one of the important part, that we are sitting in a virtual platform, all different part from the world, that we together can learn the advocacy skills. Together we can grow. I think this is one of the important messages that I also would like to highlight upon. So this is a very important thing for me. And all the scoring was also a challenging for me as a judge, because as a trainer, you all see what kind of commitment, what kind of hard work they have been, but we have to give them a score, and all the score based on the performance. So even it is not a competition, it is a learning event, but while putting the scores, it's really challenging for you to put the scores, because all students are very confident, very hardworking, and with enthusiasm they put their all the all what can all the things that what they can. So the scoring part is another important part, and it really gives some sort of encouragement to the students as well, I think. And all throughout this program, what I found, the another important is that all the judges, all the lawyers, all the partners, they all join their hand together for the cause of pro bono. They just want to do wanted to contribute from themselves to enhance the skills, knowledge, and the educational environment for the students from our region. So this is also an important thing that I found, and I really appreciate what the BAPSICLE is doing, and BAPSICLE is one who all gathered all of us into the one platform for the cause of pro bono, and it is excellent. It is excellent, and really I'm looking forward to be a part of such kind of events in future as well. Thank you so much, all of you.
Thank you, Roshani. And I think we have one more student from Laos here that would like to share the reflection on his experience. Ampon. Yeah.
Okay, thank you, Miss. And as well as I can see, the participants have already said almost everything, but I would like to make a few comments. Good afternoon, everyone. First of all, I would like to introduce myself. My name is Ampon Batikun. Now I currently study in the National University of Laos, Faculty of Law and Political Science, majoring in business law. And what's more, I had the opportunity to join as a volunteer of the clinical legal education program in Lao PDR. That's my volunteering at that time to allow me to participate in the various international event like the COE mock pre-trial hearing event in 2021. And once we have all the one of the finalists from Lao PDR that have qualified until the final round of the competition, and my role is a clerk, which was attending the event at the time to make me distressed and excited at the same time, because I feel like the clerk is the one of the position that's pretty important to allow such a competition according to the processes. And in this connection, I learned many new things from the COE mock pre-trial hearing in 2021, and I feel like the first one should be the English communication skill, because throughout of the competition, we will use only English all the time. And apart from that, I also know how to analyze the evidence, the facts, and I know how to write an opening statement, fifth examination, or closing argument, something like this. And absolutely, I feel that event was very challenging for me, due to I have a difficulty remembering about the facts, the rules of law, and especially I have to remember the many contents of the story of each person. And moreover, I afraid that the contestant and the judges did not understand me, due to my English is not pretty good. So it made me feel distressed in this point. And finally, I feel great and highly honored that have been a component at least of at least one of the event, which the event has allowed me to exchange the information, the knowledge or perspective, something like this with my friends. And in this connection, maybe I feel like it's worth a fortune or destiny to help me to meet new friends from different countries. That was one of the best experience of my life. And finally, I would like to express my sincere thank you and gratitude to the BAPSICLE to allow that event happen. And I strongly believe that there will be many great events like this in the future. And lastly, I would like to thank you so much to allowing me to add a little experience on here. Thank you so much.
Thanks, Ampon. And if our presenters or trainer would like to share or comment, please feel free as well. I would like to add that in addition to bicycle, there are also many people, lawyers and organizations, including Case, DLA Piper, New Perimeter, and Herbert Smith Freehills and University that work together to make this happen. So on behalf of bicycle, I also would like to thank all of the trainer, partner, including our presenter, for your pro bono commitment and supporting this Access to Justice program. So the program and event is growing and getting bigger and bigger. Every year we have more trainers and want to be involved and assist in the training pro bono. And more students and university want to do this. This may be can be the opportunity from the participants. If you have any question, comment, feedback that you want to share, please feel free to unmute yourself and speak up or put any comment in the chat box. I think we have got question in the chat box in Lao.
And if I can just jump in while that's being translated, if that's okay, and hopefully my computer will not keep crashing. I just wanted to introduce myself. So I'm Wendy Morris. I am one of the co-directors of Babsicle and incredibly proud of this initiative. One of the things that I did want to say at this point is that this event and the trainings have initially focused on the students and connecting the students up and mixing the students together. However, we do see and we have heard from many of the actual legal community that there's a real need to use these tools and to adapt them slightly to help to train the prosecutors and the defences and the legal community who have graduated and bring them together. So this is something that Babsicle will be exploring going forward. Again, it was initially started with the students because it's a wonderful opportunity, and I think as we saw, most students really love when they learn these trial skills and they get so passionate and so involved in it. But I just think that from the feedback that we've had in the Asia region, there's a real need to take this training and then start to also train the broader legal community, which is something that we're looking at doing going forward. I just want to share that. And can somebody please translate the Lao so that the non-Lao readers, our wonderful presenters, are able to help to answer some of the questions, please? And back to you, Anne. That was my comment.
Yeah, thanks, Wendy. I think our team will help translate the question in the chat box soon.
รบกวนย้ายไปห้องอังกฤษเพื่อแปลเป็นสดได้ป่ะเจ้าเปิดเสียงแปลเลยเจ้าโดยแปลอีกเท่านึงรบกวนเจ้าใจ
Yeah, I think there are different ways to promote the I think you mean the lawyers ethics and the rule of law and also access to justice. This type of training or legal education is also one way to promote and educate law student and young lawyer on to appreciate access to justice and the rule of law and also the ethics. Yeah. Okay, any other presenters would like to give the final shares or thoughts? Okay, otherwise, please give a big round of applause to our presenters and the students. And for more information on the mock trial event, will be on the WebSicle website. And if you are interested in assisting or being involved or participating in the training event, please feel free to contact us. And our team will send the contact email and the website into the chat box. Yeah. Secretariat, please, can you send the email contact and the website for more information? Okay, thanks everyone. And the Secretariat will share the secret word for any one of you who want to claim for the certificate. Okay, thank you. See you at the closing session. Thanks, Jishang and Roshani and Philip also.